driver for. So, again, I think the officer showed quite a bit of restraint. Oh, he says I wasn't doing any of that. Okay, so good on him for denying. So the officer is confusing because this guy's asking like, what crime have I committed, and the officer's like, he's detained, which doesn't require.
MERB, you're a fucking jackboot idiot, and you're up here saying what they're doing is not illegal, justifying the fucking cops doing it, and then want to tell people they're idiot for knowing their rights. Man, eat a dick, dude. You're part of the fucking system. You say all these bodies are separated, the cops and the DA, they all work with the same goddamn system you do, you jackboot fuck. The court system. And you say they're separate? Who in the fuck do you think you're fooling, you fucking idiot?
So probable cause.
MERB didn't roast me. He's a fucking flapping cocksmoker that thinks he's fucking all fucking mighty in the fucking law and shit. And that his opinion's a fucking right one. He's a goddamn idiot, and he's part of the fucking system.
So maybe
trying to out here fucking preach for them cocksuckers. Fuck that piece of shit.
149 did it, but it's not. It's above a possibility, but it's not. It doesn't require a more likely than not. It's a fairly low bar. But he's saying, like, look, you're just detained at this point. This is reasonable suspicion.
Detained is legally arrested, dumbass.
Reasonable suspicion. All I have to do.
Reasonable suspicion is not doing exactly what the cops do, and fucking just because they don't like what we do or how we look. Do you hear what the fuck you're justifying, you fat fucking idiot?
Be able to articulate facts, which obviously he can because he did it to get a arrest warrant. So all I have to do is be able to articulate facts that would lead a reasonable person to believe that crime was committed. Easy one to squeeze.
So now you're making judgments on what a reasonable person is and isn't. If they're not breaking the fucking law, and if they're doing what cops are fucking doing, following motherfuckers around, filming them with fucking assault fucking and tactical fucking gear, man, get the fuck out of here, dude. Fucking, what are you, a little fucking shitler, or was you on your fucking knees blowing that motherfucker and telling him what a great idea the Zazie party was, huh? You fucking idiot.
In some states it's true that you only have to be detained for suspicion of a specific crime to be obligated by deed. No, again, James adds his own interpretation. You don't have to be detained for a specific
you don't
crime.
Add your own interpretation, huh?
Because crime is...
Yeah, you do have to fucking name a specific crime.
Reasonably believe and be able to articulate specific facts that would lead a reasonable person to believe that crime is afoot.
Dude, you're a fucking idiot. If they've got reasonable suspicion and shit there, then they can articulate what goddamn crime they think's a fucking afoot there. You fucking idiot. But when you're walking around legally in tactical gear, armed, and that's a fucking good American. That's a fucking patriot. And so you got a problem with guns, you can tell it when you say, motherfuckers, I have guns. Man, fuck you, like that makes somebody bad, dude. What makes motherfuckers bad is fucking idiots like you. Y'all bought into the goddamn blue line bullshit that anybody that ain't wearing a costume and a fucking badge is a fucking danger to fucking people in general that are armed. No, we're just a fucking danger to the goddamn fucking jackboots, motherfucker. Yeah, fucking, your fucking ignorance fucking amazes me.
But in those states, let me emphasize again, you have to be lawfully detained for suspicion of a crime. If there's no suspicion, but they don't have to prove to the detainee that...
Yes, they do, motherfucker. If you're going to violate my goddamn rights, you got to prove it to me, motherfucker. You can't just walk up and lay hands on me. No. Because, see, I've got not only a right, I've got a duty to resist. To resist at any cost and at any price me or the motherfucker trying to do it has to pay. Not only a right, it says we have a duty
detainment was lawful. They don't have to prove to the detainee that there's reasonable suspicion.
Yes,
or
they
articulate
do.
the facts. It's
Do you know what RAS stands for, fucking you dumbass? Reasonable, articulable suspicion. They can't walk up and demand my ID or nothing else without fucking telling me what crime they think I've committed. You know what the fucking amendments are about, huh? Fourth and Fifth the fucking amendment, fucking travel freely and be fucking secure in a person's property and effects. What'd you do? Go to the fucking University of fucking Shitler? Little dude with the fucking mustache, or you just worship at his throne?
Of a crime. They weren't legally or lawfully detained. The officer has now articulated that they are all detained and that there is absolutely no suspicion of a crime.
well, so yes, they are detained. The officer has said that there's suspicion. Again, he doesn't have to say that there
Yeah, so you got to tell you, motherfucker.
is that he doesn't have to say that he believes they've committed a specific crime. But if he has reasonable suspicion to stop the driver, then all the
Now, hold on. No, we're separate from the driver's all on his own. Everybody else in the car is not connected with fucking traffic stop. You goddamn jackboot authoritarian motherfucker. Now I know why you never fucking, when I was around before, you wouldn't let me in the fucking server, motherfucker. I'm not your assistant. I am your ass kicker, dumbass. Fucking, you know better. And you still know better. You'll talk fucking smack from over there. You fucking weak-kneed cock whore.
passengers are also detained. It's
No. That ain't right, MERB. You spitting out bullshit fucking just because that's the way you want it to be. A fucking passenger has nothing to do with the fucking traffic stop.
that's just the way it works.
That ain't the way it
You detain
works.
the driver, you detain the passenger.
No.
And that's not a violation of the Fourth Amendment. It's whether or not the officers have reasonable suspicion to stop the driver.
The driver. You excluding there, but then now everybody else is responsible for the fucking driver? Are you fucking... Good God. How fucking stupid can a motherfucker be? Or how fucking brainwashed?
I understand that some people in our society are really fucking stupid. But this officer,
We're gonna let James Freeman go through this a little bit, and we're going to wonder if James Freeman has ever realized that he could be talking about himself.
that they are all detained and that there is absolutely no suspicion of a crime. I understand that some people in our society are really fucking stupid. But this officer is both really fucking stupid and really confident that he's not really fucking stupid.
Martin, he was talking about you and jackboots like you, program fucking puppets. You're sitting over there part of the system, but yet you sign a contract with the court to be able to practice law. So you're under contract, just like the DA is, just like the judge is, to the same fucking master. And then you steal people's money telling them that you're going to fucking defend them or whatever to the best of your ability when you're back there cutting up the fucking pie with other cocksuckers and still selling your client down the fucking river, motherfucker.
James Freeman is really fucking stupid. He's also really fucking confident that he's not really fucking stupid. Well, he is really fucking stupid.
Here's your mirror.
You think the cops are going to find that marijuana grow?
Fuck MERB. That motherfucker's dodged me for years. 5 years to be exact.
Are probably what makes some of the most dangerous police officers out there.
Ignorance, stupidity, and what was the other one?
There ain't nothing to debate. Not really. He's over there fucking preaching the fucking blue line
Back up.
and fucking
Back
stealing his clients' money when he's selling them out down the fucking river.
Something. Let's see what you got. Ignorance, stupidity, and ego combined are probably what makes some.
MERB, you need a mirror.
James Freeman dangerous. Because James Freeman is out here teaching people all about this, about James Freeman's understanding of the law, which is completely antithetical to what the actual state of the law is. To how the law
Which version of the law we talking, MERB? commercial,
So,
code of conduct,
ignorance, stupidity,
fucking
James
commerce.
you wear it
I mean, what are we fucking talking about? Marsh, natural, maritime.
And again, like he just assumes that these auditors know the law. He just assumes it. And they are as ignorant or more ignorant than the cops, because the cops knew that they could make a stop.
Nah, you're defending shit, calling everybody, the fucking citizen ignorant and everything else. Say, well, a cop really ain't got to be able to articulate the law and know the law that well done. You ignorant motherfucker. If they're law enforcement, they ought to have that shit down to a fucking T. And if you're going to have fucking guns, they ought to have fucking 50 years of goddamn schooling. And be able to fucking be crucified on a cross and fucking plunged in the side with the spear, buried, and then fucking get up after 3 days and said, I'm back. You fucking moron.
Unreasonable suspicion of the driver and demand from the driver his ID.
You may not give false identity. When arrested, you must identify. Straight up, no question about it.
He's assuming. Yeah, fuck you, Mark.
Somehow I doubt that this guy's going to spend 5 years in civil or criminal litigation.
He's a dick, MERB.
What's his name? Ross Sands. He's going to spend the next 5 years in court, criminal and civil.
I doubt that. I think that HBO Matt is a little overly optimistic. And why doesn't Freeman call HBO Matt out on that? Why doesn't he say, HBO Matt was really wrong when he was saying that, but
Well, MERB, why don't you call the law out on that? Like, stop, motherfuckers, just because they was filming, you and I both fucking know it. And you're sitting over here fucking defending the cops. And you're actually acknowledging, for one, your inside knowledge of the fucking system and how it works, and that, we all know that 1 in a fucking 100,000 of fucking legit cases hit the fucking courts. Because otherwise, the corruption in the fucking system that you're a part of, that you're under contract with, fucking makes it go away. Just like they did down in fucking Idabel, planning on fucking, planning the fucking murders of fucking reporters and fucking newspaper people, motherfucker.
Unfortunately, HBO Matt is completely wrong about that. Cops don't get criminally charged for illegal detainments, bullying, and intimidation.
they don't get charged for illegal detainments, bullying, and intimidation. Wow. Except when they do. There are cops who go to jail.
1 in 10,000.
They are sovereign citizens, meaning that they are not accountable to the laws that everyone else is. Are they committed?
James Freeman likes to make up his own definitions for words. It's amazing how much easier life is.
Well, let's just see here. We'll ask fucking Google, MERB. Define sovereign citizen.
Here's the definition of sovereign citizen. A member of a political movement of people who oppose taxation, question the legitimacy of government, and believe that they are not subject to the law.
Yeah, well, they've changed that. Well, give me a minute. Define sovereignty.
Here's the definition of sovereignty. Supreme power or authority.
Supreme power or authority. The authority of the state governing itself or another state. National sovereignty. And what was that again? Yeah. Anyway, go ahead, MERB.
When you reject everybody else's definitions, and you use your own, because then you're never wrong, right? Well, according to my definition of sovereign citizen, cops are sovereign citizens. Yeah, cops are the real sovereign citizens, except they're not.
Yeah, I believe they are. Supreme power or authority, sovereignty. And it says, how can we hope to wrest sovereignty away from the oligarchy, and then back to the people? We're not the one that claims the right to tax motherfuckers. We're not the ones that claim a right to rule a motherfucker. We're not the ones that, well, actually, by the way it's written, we are supposed to be the ones fucking with the supreme power over punk ass bitches like you in the fucking system.
Crime here? Yes, absolutely. Caught or not, when you hold someone against their will without RAS, it's called false imprisonment.
False imprisonment. Oh boy. Texas Penal Code, false imprisonment. We're going to do this. We're going to do this, boys and girls.
Here's another one. Sovereignty in the political theory, the ultimate overseer or authority in the decision-making process of the state and in the maintenance of order.
20.02. So 20.02. 20.02. So this is as close as they got to it. A person commits an offense if he intentionally, whoops, there we go. A person commits an offense if he intentionally or knowingly restrains another person. Is an affirmative defense in this prosecution that a person restrains a child under 14, the actor's relative, the actor's sole intent was assumed lawful control of the child, an offense of the section, yada, yada, yada.
Yada, yada. Read it all, Merb. Yada, yada, yada. Sound like a cop. Don't want to read the shit that don't go with what you got to say. You're just looking for the one that fucking backs you up. We see how it is.
So it's a felony if they restrain a peace officer or a judge.
So they're higher class than a fucking common man?
It is no offense to detain or move another under the section when it is for the purpose of effecting a lawful arrest or detaining an individual lawfully arrested.
Lawfully arrested.
So
when they ain't got any legal means to do it.
That if it is an unlawful arrest, and an unlawful arrest requires more than just, well, the court finds you didn't have probable cause.
No.
Officers get some leeway because no one knows.
Yeah, get some leeway. Why in the fuck don't we get leeway? That's what sovereignty is, you fucking idiot. Because we're not sovereign. We know them rules don't apply to us.
Not the officer has probable cause until a judge makes that determination. So there is some leeway there. It's not an unlawful arrest just because there's a determination that there's not probable cause. It requires more than that. And I'm not going to go into that.
You know, like what we see just about every time, cops planting evidence, making shit up, lying on a fucking report. You mean it requires more than that? If they're not able to fucking make a determination of reasonable articulable suspicion and then fucking move from that and have substantial probable cause and know what that is, should they be out there enforcing the law? And should fucking idiots like you be up here fucking defending it?
But you get the idea.
Yeah, I get the idea. You're a fucking idiot. That you're a fucking jackboot authoritarian that is part of the goddamn system. And you're out here fucking trying to tell people that are fucking breaking away and waking up that how wrong and stupid they are. And trying to preach to the fucking masses that that it's all wrong. All the while making money off the private citizen while you're under contract. You're an officer of the fucking court. That's the reason you have a fucking dress code when you go in there, and I don't.
So it's an affirmative defense if they're children, and it's an affirmative defense if it's, again, a child. Weird.
It's weird that
Texas,
you can't handcuff a child, Merb. You find that weird?
Oh, Jesus.
That's it, yeah. You're gonna lose the next 5 years of your life in court, bro.
Some I don't think the cop's going to lose the next 5 years of his life in court.
Are you gonna give me your license or I'm gonna arrest you for failed ID? 20. Are you of equal rank? Good. If you're gonna give me your license, are y'all of equal rank? Yes, we are. So just so you know, if you let him do this, you're in jeopardy also for failing to intervene. So you don't not have a dog in hunt. You don't know our communication. Hey, I don't care. I know the law. You don't know it doesn't matter. It doesn't matter if you let him. You're an equal rank. If you let him do it, he's not your superior officer. You're gonna.
When's James Freeman going to jump in on this? This is a bit of legal advice each year. I'm not kidding. Because obviously this didn't come to fruition either.
So let's see. Okay. I am just making both of you fully aware of what this decision entails. I'm not asking what you communicate to. I'm fully informing you of the risk of what you're doing. Okay. We're not talking qualifying you.
We're not talking qualifying here. We're talking criminal here. The cops have done nothing at this point that would
An illegal
make them
stop.
criminally liable for shit.
An illegal stop.
De lo que está diciendo él de no presentar esa identificación. Solamente me puede identificar si me ha arrestado por un crimen. Es la única forma. Es la única forma que me puede arrestar.
It's the only way. Where are you going to jump in here, Freeman? We're going to jump in here. They can lawfully ID you at a driver's license checkpoint.
No, they
As long as
can't.
They meet the constitutional requirements of having a plan in place, this and that and the other thing. So are you going to jump in there, Freeman? Or are you just going to ignore that bit of wrong advice? And again, you're totally ignoring the transportation code, Freeman. Isn't that weird?
You know, transportation code is for those under contract with the state and commercial drivers. Something else they lied about.
The cops are.
They are.
These auditors who are misquoting the law and misunderstanding the law. Oh, no, these guys are the right ones. But cops are the ignorant, egotistical ones.
They are.
You want to
Just
talk
like
about
you.
ego?
You
These
look.
idiots in the car with zero fucking legal education are trying to tell cops.
So you got to have a legal education to know your fucking rights
Enforcing the laws.
and what's
Probably
right and
have
wrong.
Daily briefings on what to do and how to do it. You probably have to go to various.
MERB, bitch boy, you're talking in fucking circles. You're over there saying they're too goddamn stupid to understand the law or to really articulate it good, but yet that they fucking do it day in and day out, and they've got a legal fucking education, and they have all these briefings from other motherfuckers that ain't got a legal education. Now, they've been brought up under policy, you know,
continuing education classes to at least understand on an application level the law, not necessarily the nuance of the law, but on an application level the law.
Then MERB, then how come they don't know the application level of the fucking law? And if they knew the application level of the law, then and followed it and fucking actually enforced the law instead of their fucking feelings, let's say, we probably wouldn't have all them fucking determinant of a fucking unlawful arrest or lack of fucking cause, if the cops could do their jobs right. You know, COP stands for Citizen on Patrol, not a fucking officer of the court.
And the idiots in the car and James Freeman with zero fucking understanding have the ego, the unmitigated balls to try to clown on the cops when they don't even know what the fuck.
Apparently, no. I mean, I know he's been arrested a few times. Hell, most of us have. The ego is what reflects you in the mirror every day, dipshit. And the fucking cops. We are the masters. Y'all are beneath us. And so you're fucking one of the worst ones, MERB. And, you know, from what I understand, you fucking private practice this shit and another. And you'll fucking take your client's money when you're sworn to work for him and all this other bullshit. When you're under a goddamn contract with the fucking court you go before. You've signed a contract fucking of all kinds of shit and loyalties to the fucking court. And you won't fucking take your client to the fucking extent of his fucking rights. You'll try to convince him to fucking plea out or fucking make a deal or whatever. For one, because you're a lazy fat fuck. And two, you know, you don't give a fuck. You don't give a fuck about their rights. You give a fuck about putting money in your fucking pocket. And you're under contract with your buddies in the fucking court.
They're talking about.
Es la única forma. De todos modos, no ha dicho ninguna violación, ¿no?
Fucking idiot.
Yo hablé con él, ¿tienes un supervisor? ¿Un gerente? Necesito un supervisor aquí porque necesito un. Necesito tu permiso. What do you do?
Y'all know everybody sitting there watching MERB. He subscribes to the same bullshit that the elite do, that fucking Clinton, Obama, and everything else. You common people are too stupid to know your fucking rights. You're just too stupid. You know, and you got to have fucking, a lawyer certificate where you're a member of the fucking establishment to even have any idea what your rights are. So you don't know what's right and wrong, but we do. You fucking. I'm glad I ain't got an answer for you. And your kind.
¿Qué es la causa probable? ¿Qué es la causa probable?
You have every right to make contact and investigate. That's it. Nothing more.
Again, see, where's Freeman jumping in and correcting HBO Matt's misunderstanding of the law?
Oh, just because you said it's a misunderstanding.
Stop an ID safe. The cop does not ever have the right to just stop you for no reason and ID you. RAS is always.
That's right.
You're misunderstanding.
No, there ain't no misunderstanding. You're trying to fucking muddy the waters there, son. We have freedom of travel. And unless it's obvious that you're the fucking puppet here, MERB, and you're going to defend these goddamn jackboots. You're going to be down there slobbing their fucking knobs, stealing fucking private citizens' fucking money right along with them, being part of the establishment, an officer of the fucking court. Now, and then say, well, you got a misunderstanding. You don't have a right of freedom of travel. You know, if you hurt a cop's feelings, they can, abuse the powers and authorities given them to you, by you, supposedly, and then fucking violate all your rights, stop your freedom of fucking travel and everything else, all out of retaliation, because simply we know, just like the cops, and just like you're showing us, your buddies in the fucking club don't like it when we fucking hold you accountable and put you on a fucking camera. And y'all will do anything to fucking defame, fucking defile, abuse, or fucking, mistreat in any fucking way you can, especially on paper. And then say we had the misunderstanding. But I understand you fucking plain and clear. You think y'all are the fucking masters and that y'all fucking rule and that we don't understand our fucking place. I understand my place, boy.
Stop an ID, again, you're redefining it beyond what its intention is. Wiretap.
Nah, how do you know the intention? Was you one of them that wrote up the fucking bill and helped introduce it? Was you one of the authors of the fucking bill? I'm just asking. Huh.
Which one? Right here. You don't look it's the popular. Yes, sir. That's what I see. Well, now I know you are. So I will be happy to let you go.
Wow. The audacity of these cops who, even though they could issue citations for the failure to ID of the driver,
no, they can't.
as soon as they know who these guys are, they let them go. How fucking dare they?
To violate, you're right. How dare they violate a motherfucker's right to be secure and his person property effects and shit, man.
Oh, but you're going to say, but John, they went and got an arrest warrant. Well, here's what they did. They presented the facts to a judge, and the judge said, you know what? That's a fucking crime.
You know what else is a crime? You know what else is a crime? When they fucking arrest you, they're supposed to take you immediately before that judge or magistrate. Immediately. Not book you into jail. So let's talk about what the real crime is there, dipshit.
Give you an arrest warrant for it. And apparently, they don't do anything on this arrest warrant for well over a year. then I'm going to assume they finally got a grand jury to issue a true bill for the arrest of these guys. All of a sudden, but it's the cops. It's these cops, these asshole cops, who let us go after turning who we are.
Yeah, when you violate somebody's right to generate a fucking police report and have their fucking name in it.
So,
yeah, there's violations of shit all over.
Apparently, Chili served Kate about a month ago, and now he has an entry of default. So your question is, what does that mean? What does it mean to have a default? See, there's court judgment, clerk's judgment, or entry of default. You can get an entry of default with the court judgment. You can get an entry of default with the clerk's judgment, or you can just get entry of default. So what does entry of default mean?
So how can a clerk make that judgment? Who give her that fucking legal education?
So yeah, there is a default. What that means is it basically cuts off Kate Peters' opportunity to file an answer. She can no longer file an answer to the complaint. Essentially, it means what? They accepted this without this page filled out?
All legal and shit, huh?
That's right.
Especially when somebody can't answer a complaint against them. That sounds righteous.
Essentially what it means is that Kate Peter can't file an answer. So the court is going to essentially assume liability. So all that Chili has to do now is get a judgment. And I'm not going to give him any hints, but that's his next hurdle, is to get a judgment. And I don't think he's going to have such a good time with it. So yeah. So you can see that if he does request a court judgment, testimony is required.
I thought it down. I didn't realize that was
if he can go that route.
So I ain't trying to fucking throw all that shit
so I'm not going to give him any advice. Then he would have to go down this particular route, and etc. So he's got some hurdles ahead of him. So that's what's going on with Castro, or at least that's the last thing I'm aware of that I'm actually following with Castro. So next up, Earl David Orden, the man whose name hasn't crossed my lips for a month. Man whose name hasn't crossed my lips for a month.
I don't give a fuck nothing about this.
Teresa Richard was kind enough to give me a copy of the transcript for the hearing on the motion. Now, I want to be very, very clear. If you watch my videos on the motion for a new trial, my point was, and I said it, I might not have said it in every video, because I made several videos on this particular thing.
Y'all be clear in your shit what you want to say.
The allegations that were made in the motion were true, then a court should grant a new trial. Now, the court did not grant a new trial, and so there's an appeal. What they're going to have to do to prevail on appeal is they're going to have to show to the Court of Appeals that no reasonable judge.
You can't have an unreasonable judge.
Look at the evidence and come to that conclusion. It's an abuse of discretion standard.
You just said a while ago that law enforcement shit can't be unreasonable.
No reasonable judge could have come to that conclusion.
We got storms coming, y'all.
It's,
I guess
generally speaking,
I'll be back in a sec.
that Earl is going to lose, unless there's some real issue
I gotta
here.
go put some shit up.
I haven't seen. Although
I'm gonna film storm.
I have not really gone through this. I have read it, but I haven't done any research on it specifically for this. So on the 22nd day of 2023, the following proceedings came to heard the above entitled and numbered cause before the Honorable Judge, the Honorable James Anderson, Judge presiding. So we have appearances, Simone Colson for the state, and Garris for Earl. So, okay, so, yeah, was found guilty by a jury on a second-degree felony of sexual assault on a child. Let me double-check my younger than 17 years of age. It was filed as a second-degree felony. The indictment indicated a prior conviction some years earlier of the felony offense of aggravated sexual assault. This was a multi-day trial with more than a few interested parties. And for the defense, let me check real quick. Mr. Garris, present for the defense. Ms. Colson for the prosecution. Mr. Garris, beyond what you've already filed, which I may say is an incredibly good work product, I have received this morning 2 more affidavits, one from Jennifer Perez and one from Patrick Roth. I've read and notated all your affidavits in your motion. Is there anything to add above and beyond the filings you made in the case? Courts, generally speaking, hate it when you just rehash what you've already written. The court's read it. He's really making it clear. I've read it. So is there anything else? This is your opportunity to make any arguments that maybe were raised in the state's opposition, or maybe raise new points that you forgot to add. This isn't a case of just rehashing what's in it. So Garris says, Judge, there's nothing to add except those 2 new affidavits. I have not formally filed them with the clerk as of this time. And so what I've done with respect, or for purposes of this hearing, is I have made, I guess, printouts and have marked as defendants defendants exhibits 1 through 12, all the same exhibits that you have copies of currently, with the addition of exhibits 11, the affidavit of Patrick Roth, and exhibit 12, the affidavit of Jennifer Perez. So you have copies of everything, but just for purposes of the record, I move to introduce these formally at this time. So he offers them. The one that you want to make a change on Ms. Perez's new affidavit, you have entitled affidavit of Patrick Roth. Mr. Garris says, and I'm sorry, Judge, and I caught that I did not prepare those affidavits. I think they were prepared by another lawyer, if I'm not mistaken, but I saw that it's both the top and bottom, but the body of the affidavit states the name, and then signatures on the back also state her name. So even real attorneys, expensive attorneys, good attorneys, can have minor mistakes like this. So you don't necessarily want to throw out the baby with the bathwater. Just because an attorney or a pro per litigant makes a mistake doesn't necessarily mean it's a fatal mistake, as in this case. The court says, yeah, I'm just making a scratch on my notes right here. Put this for Ms. Perez on my notes. Okay. Ms. Colson, defendants 1 through 12 affidavits. Colson says, no objection, Your Honor. Court says, I'll admit 1 through 12. Court says, folks, I have literally read and made notes on every single affidavit that Mr. Garris was kind enough to file almost 3 or 4 weeks ago. I've been carrying around a special folder for the Warden case for a month now. Good. Beyond those 11 or 12 affidavits, Mr. Garris, anything else to add evidentiarily speaking? Mr. Garris says, no, not from an evidentiary standpoint, Judge. Court says, and defense will rest the evidentiary phase? State, anything to add on the evidentiary phase? Colson says nothing, Your Honor. The court says state will rest. Mr. Garris, your motion, your right to open and or close a final statement as you see fit. Mr. Garris says, well, Judge, I think you've had a chance to review the motion for your trial. You've raised 4 claims, 3 of which are pretty heavily interrelated from a factual standpoint as it relates to evidence of both race and religious evidence into the trial. We think it was evidence of racial and evidence of kind of religious stereotyping is probably the best way to characterize it from our vantage points. But we've raised 3 claims that relate to that, and then another claim, which was claim 2, that relates to outside influences making their way to the jury. I think for purposes of the first 3 claims, which are claims 1, 3, and 4, probably the most helpful place to begin is the Superior Court's holding in Dawson, or the Supreme Court's holding in Dawson versus Delaware, which effectively holds that a person's right of association under the First and 14th Amendment, first, the First Amendment right applicable to the states to be a due process under the 14th Amendment's Incorporation Clause, but that prohibits the introduction of evidence of a person's association. Here, the evidence of association would be with the child that was made the subject of the racial commentary in the trial. But where that has no bearing to the issues that are relevant to the legal issues in the case, that constitutes a First Amendment violation. That Dawson case has been extended to not just the evidence of a right to association, but also religious animus and other parts of the First Amendment. The cases that are cited in our brief, but it's also been extended. Dawson itself was a case about, it was a death penalty case where evidence of the defendant's membership in an Aryan Brotherhood gang came in during the sentencing phase of the trial. But because it wasn't relevant to any issues in the sentencing framework of the case, the introduction of that evidence was seen as infringing on his First Amendment rights. That dealt with this evidence in the sentencing phase. The Texas Court of Criminal Appeals has applied Dawson's holding to the guilt-innocence phase of trial as well. Guilt-innocence is where they find you guilty or not guilty, and then sentencing phase is once you're found guilty, then you move on to the sentencing phase, and they're allowed to, the rules of evidence are somewhat different there. They could bring in more character evidence, things like that, in the sentencing phase. Once they've already determined, once the jury's already determined you're guilty, then they can start taking.
I gotta go catch a chicken and I'll be back in just a minute. Sorry I left y'all alone just goddamn idiot so long.
And that's where this evidence came in this trial. And so we think that's really the most helpful starting point, is that this type of evidence that was introduced is not relevant and does violate his First Amendment rights. It penalizes him for what the state alleges was his exercise of First Amendment right not to be associated with someone on account of race, and impinges on this kind of allegation that he was a Mormon and was trying to get someone to convert to Mormonism so that he could marry that person. My understanding is that's the complaint, or that's the complainant in this case. Well, with respect to the first issue, there's just patently no saying that he would not associate with a black child that his wife had become impregnated with has nothing to do whatsoever at all with any of the issues involved in the case. And it only serves the purpose of prejudicing him. And then if we look to, and so we think it's clearly are. And then the question is, what kind of analysis should you do in analyzing the harm of this? Because it's of a constitutional magnitude, we believe that a harmless error test applies, but that a harmless error test the burden shifts because it's of constitutional magnitude to the state to show that it did not impact in any way the introduction of this evidence, which came in during trial and was also emphasized in the course of the argument, did not impact the trial in any way. And we think that the Dawson case itself recognizes that harmless error could apply. It left the question open. And then the Dawson court on remand back to Delaware, they applied that harmless error test, but where it's harmless error of constitutional magnitude, that shifts to the state. So that's claim one. Claim one heavily relates to claim 4, which is our ineffective assistance to counsel claim, because there was no objection when this evidence was offered. Well, there's no objection to the evidence of the racial animus. There was no objection by trial counsel when it was offered. We think that's sufficient performance under Strickland not to object to the type of evidence. The court says, I've got a question for you. That is, generally speaking, the last thing an attorney wants to hear. Garrett says, sure. The court says, I remember, and it's been about 2+ months now, that it came up during trial that Mr. Warden's ex-wife had a child by another man, and he was either not comfortable raising the child or her being pregnant in the marriage. And she subsequently came back to the marriage after she had the child and perhaps put it up for adoption. For the life of me, I don't recall the age of the father or the child was mentioned. It may have been. It was a really tedious trial. Do you, by any chance, have a transcript that says black? Because I don't remember race being an issue. Let me think on that for a second. If you recall, Ms. Colson, do you recall that the father of the out-of-wedlock child was a different race? The person says yes. The court says, okay, I'm glad you do, because I recall the surprise event that she had another child outside of wedlock, and she was outside of marriage for a while, and then came back to the marriage. But apparently race was mentioned. I take your word from both sides here. Mr. Garrett says, and just so you know, Judge, I don't have a copy of the transcript. What's in the head? Mr. Garrett says, and so moving forward to the deficient performance prong of Strickland, we think it's deficient performance for a number of reasons. One, because this is a criminal right? But second, allegations about this type of evidence were not noticed in the state's 404B notice. They were not noticed in their 38.37 notice. Those would be various statutes, I'm assuming. And they have not been, and it would not have been admissible. That type of injection of racial and religious type of testimony would not have been admissible had counsel simply objected. Trial counsel himself, Mr. Andrews, provided an affidavit, and that's That's one of the affidavits that you have. It's Defense Exhibit 2, where he recognizes that he was caught off guard and failed to object to that. So he recognizes his own performance there. It also can't be a matter of strategy, trial strategy, to not object to something because you're caught off guard by it. And so it can't be the case in the trial strategy. He gives wide latitude to strategy, but that was not, he did not identify that as being a strategic choice, and in fact recognizes that it was his own mistake. The question is, for the purpose of Strickland's second prong, the prejudice prong, what effect does this have on the outcome of the trial? Is there a prejudicial effect? One, because it's a lack of reliability to the outcome of the proceedings. And there's a couple of things to that, Judge. One, this was, as you recall, a very heavily contested, tedious fact trial that at the end of the first day of deliberations, resulted in the jury informing the court effectively that either they were 6-6 split, or that 6 thought the deliberations would help continue, or help that continued deliberations would help. But they left that day very much split. Now, I get ragged on by, what's that little shit's name, the Crown Bandit? Because, oh, you don't know, I was there, and it wasn't a 6-6 split like I reported on. Well, apparently, even the fucking defense counsel thought it might have been a 6-6 split, or that 6 thought it wouldn't help, or something. So, Dougie, you're a piece of shit, and I hope you choke on one of your friends. And the deliberations continued into the next day. I know that there were, for purposes of this portion of the argument, there were a number of juror notes that came back that really looked at the credibility of testimony, issues that were brought up by both parties during the trial. Allowing the injection of racial and religious type animus and stereotyping affects the interpretation of that type of credibility at trial. This was the case from 1997, it's the date alleged in the incident. So we're talking about 26 years ago, something maybe my math is wrong, but about 26 years ago. And this was a trial that had no physical evidence. I think there was at times allegations that had been investigated and then not investigated. I think there's an investigation into Mr. Warden. She misspelled the name wrong. At one point that went nowhere. I think all that's discussed in Mr. Andrews' affidavit. You're right, since the state was, all the testimony they presented was impeached and contradicted by some other testimony that the defense raised. So ultimately it comes down to credibility determination of the complainant and a credibility determination of the defense evidence in the case. And that credibility gets a huge bolster when you start injecting racial animus and religious stereotyping into the case. To say that he, Mr. Warden, excluded the child from living in his home on account of that child's race has absolutely zero to do with any of the fact issues or the legal issues or the elements of the crime. And then to suggest, well, to raise that, and then to emphasize it in the closing argument only serves one purpose. And that one purpose is to inflame the jury to dislike Mr. Warden. Mr. Warden should have had a trial that was free from that type of evidence. And had he had a trial that was free from that type of evidence, we can't say that the resolution of those crimes may have come a different way. And that is enough to meet the prejudice prong of Strickland. He doesn't carry the burden of showing beyond a reasonable doubt that he would have been found not guilty. That's not the standard. The appropriate standard is to look as to whether we can have faith in the reliability of the outcome of that proceeding. And even though the juror notes reflect themselves, they have engaged in deliberation, the question you have to answer, we could judge, is whether whether a juror is going to go back and analyze that presented evidence and consider it in a negative way. And is that going to affect their credibility determinations in a case that has no physical evidence, a case that didn't have contemporaneous allegations, and a case where she said, hey, I had been touched every day for 2 years, and the defense recognized there's some serious implausibility to that. And so all these claims can relate. The third claim and that's the Strickland analysis, moving to our claim 3, we think that evidence of racial and religious animus and stereotyping is also false and misleading. And we think that the presentation of that also violated due process. The affidavit that goes to that issue is affidavit 4. It's the affidavit of Kathy Hart, who's known Mr. Warden since they were children, recognized that Mr. Warden has never been Muslim. She's never known him to be racist. And like I said, that issue is both patently false, but also is irrelevant to any issues in the case. And then the last big issue is our issue number 2, which relates to outside influences that come to impinge on the jury in this case. There are various and numerous outside influences. That's the subject of many of our affidavits. it was a subject that came up during the trial that she recognized, Judge, and it included this individual, John Gray, who followed jurors outside the courtroom. I think that was probably the main focus of our presented claims here. Just as an interjection,
Not a problem.
I don't like Earl. In fact, it specifically stated that I consider him to be a threat. And if he ever shows up on my
Well,
doorstep,
I'm back. I got
will
so
defend
lost,
myself
everybody.
appropriately, assuming he is a threat. I will assume he is a threat. I have trespassed him from my property.
What's up, old
You don't
man?
like the man.
Hey, I just seen you.
But I can't think of
5:08, I don't
any
even know what time it
argument
is.
I have ever seen him say or do anything racist.
Man, I'm sorry, brother.
I mean, the first time I saw him, he was cop watching with Philip Turner. I would not assume he would go cop watching with a black man if he was racist against black men. My assumption. Maybe my assumption is flawed. I don't know. But for all of Earl's faults, I don't fault him for being. I don't believe he's a racist. What was following two sets of jurors to their cars is what we understand was reported. I think that's what you had received back and forth and had made note of. But there were other attempts to influence and talk to jurors. There was an individual that tried to hand pamphlets out to Mr. Warden, to jurors as they walked out. And these pamphlets, and the person who was handing them out, is someone who is pretty well known and established as being kind of an anti-Mr. Warden. I'm sure the pamphlets were written in crayon, if they existed. And by way of background, I think you know, Judge, that, and it's discussed in the affidavits, that he is involved in a community of kind of First Amendment, I don't know, I've heard different terms used for it, the kind of First Amendment
Hello.
that has prompted him to have a pretty big fan base and also have a pretty big
MERB, put your cock up, boy.
And so there were members that attended the trial that were on both sides of that coin, you believe. But this
Anyway,
individual,
old man,
Mr.
sorry
Brown,
I missed
was
you. I
associated
just shot you a text. I'm here now.
Or for Mr. Warden. He certainly sat through the trial on Mr. Warden's side of the courtroom. I think you
Hey,
should know
dumbass,
that
I
Mr.
want to know why
Brown
you're up here
that
fucking
I think it was a subject of commentary even by the court.
giving this
that
fucking
individual
motherfucker any
is
time at all.
associated and a friend of
You
Mr.
trying to
Warden's.
keep him in the fucking
But that individual following folks to their cars with
circulation.
camera, with recording equipment, with cell phone and microphone equipment, that was something that was brought to bear on the jurors. Additionally, the communications and attempts to communicate with the jurors, that same individual seen with trying to hand out pamphlets right outside the courtroom door was seen talking to jurors, and this is the affidavit of, I believe, Tara Sieber, who was seen talking to two jurors following the first day of deliberations across the street. Oh, Gray was seen. And then I know it wasn't the intent of the court to do this, but I discussed it also in a briefing about the comment was made by the court about 25 years of this, having heard about 25 years of this dysfunctional family in 2 days. And we think that is also, what's outside the record, was brought to bear on the jury. And I understand the nature of the comment, but at the close of that first day of deliberations, we think that telling the jurors to go back and, clear their heads for the evening, you've heard about 25 years of this dysfunctional family. I think the question is, well, how does the family become dysfunctional?
I am the
It
game.
could very well be the case that the family becomes
My name is
dysfunctional because
Jigsaw.
of sexual
Would you
abuse in
like
the
to play a
household.
game?
And so we think the question that this court has to answer is simply, was any outside influence brought to bear on the jurors?
The
And we
game
think all of
always
these were
wins the
separate
game.
outside influences that were undoubtedly brought to bear. The jury became aware of these things. There was also an individual that shouted, "You're supporting a rapist and a sex offender," near the elevator bank that would have been within earshot of the jury. The affidavits discuss that the bailiff had come out towards the elevator bank following that loud commotion. I think you also recall, Judge, the jurors themselves had been walked out of the front of that courtroom in the old family court building at the time. So from a legal standpoint, the question you have to ask is, it's our burden to prove this, but we think we have established firmly that outside influences were brought to bear on the jurors. And then the next question is, without delving into this jury's deliberations, you don't get to look at all what this jury did, and I've got the case law to support it. It's in our brief. But without looking at all into this jury's deliberations, you, the court must ask yourself whether there's a reasonable probability that the outside influence had a prejudicial effect on the hypothetical average juror. And so you don't look to anything that we know about this particular jury or what their deliberative process is. We look merely to whether there is a reasonable probability that a hypothetical average juror would have been affected by these types of outside influences. We think they were. We think that this court was right to exclude Mr. Gray. I myself have some questions about whether his actions would have constituted tampering, although that's not a call for me to make. But we think it's clear that the jury was affected by it. They let you know.
So if they get a little bit of,
the juror notes reflects that at the close
I ain't gonna speak to
right
that
before
because I don't
the
know.
verdict came out, they asked that they be referred to anonymously out of concern about folks in the crowd knowing their names. I think it's also in Exhibit 8, the affidavit of the investigator that we had tried to contact the jurors, that the jurors themselves refused to not be a part of wanting to communicate about the processes after the fact.
Well,
We don't
you're
look at this
not supposed to or
what
have
this
to.
particular jury did. We look at how a hypothetical
Well,
average juror
I
would
guess
have
it,
felt
they
or
can
would
if
have
they
been
want to.
impacted. You think the court says, hold on a second. You're telling me that if we know what they did, we don't look at that. We look at what a hypothetical person would have done under these circumstances. And considering,
Because,
considering,
you know, there is such thing as jury nullification.
Harris made
Where
that
if we
point
believe that
in
shit's
his
bullshit, we can fucking, we don't
I
have to
think the
follow
court
the
should have
fucking
done
law.
some research
Let's
on
talk
it.
about that, Merb.
So that's interesting that the court asked that. I didn't catch that the first time I read through it.
That don't
But
surprise me.
I do remember Garris talking about it in his brief, so that's interesting. Or at least I think I remember him talking about it in his brief. Garris says, well, that is the standard, and I've got citations for that, and there's several in there. But it also has back to a case called Coiler versus State. Coiler versus State. That is a Texas Supreme Court decision. That's Tennessee. Hold on a second. Texas.
If you read everything that quick, that's probably the way you handle your client's cases, ain't it, Merb? Just at a fucking glance, well, play out to this. Well, I didn't do it, yeah, but, you know, you've already paid me, and it's going to cost you more, you know, if, even though they can't prove it and stuff. It'd be just easier for everybody if you just pay me, and I'll go cut it up with the guys in the back room, and then you can pay some more fines, and, you know, whatnot, you know,
Courts use the
everybody
objective,
report
reasonable
Merb stream
person
for him
test
showing
to
his
decide
cock
what
in his
effect a
stream. Do it.
particular outside
I see his
influence
cock. Do y'all see his
communication have on a
cock?
hypothetical juror. We do not allow testimony about what the effect had upon this particular juror. So I do believe that Mr. Garris is correct.
So who determines what fucking hypothetical and what their fucking response would be? Oh yeah, the powers that be.
That's Texas criminal appeals case from 2014. But the citation that I have for this judge, and it's on pages 17 to 18 of our brief, we cite to the Woodman and Coiler in the Corey case that Sampson's proposition. So he has 3 cases. Now, the Texas Court of Criminal Appeals is the highest court in Texas as far as criminal matters are concerned. The Supreme Court only deals, the Texas Supreme Court only deals with civil matters in Texas. The Texas Criminal Court of Appeals is the highest court for criminal matters.
Seems kind of rigged to me.
His argument was correct. Apparently. That's a qualified apparently. It appears to be that way. Now, is there some other newer case that changes it, that adds a wrinkle to it? I don't know. I haven't done all the
You mean a wrinkle like the fucking legal
operate under
farce,
assumption that
the straw
an attorney
man?
of Garris's caliber would have done the research. He's getting paid probably a metric buttload of money
It's all about the money, ain't it,
to
Mark?
do this appeal, and he probably has some professional pride in it. And having
Yeah,
read
the
his,
pride gets in the way of
motion,
fucking doing the right
he
thing,
seems
don't
to
it?
be a good attorney. He remembered his citations to Coiler, Woodman, and McQuarrie, so he spent some time in there. I have to assume
Oh, you're good at that,
Yeah.
boy.
he has shepherdized them. No, Earl is my operating assumption has always been and remains that Earl did it. I just want Earl to get a fair trial, and I don't think that's unreasonable to want Earl to get a fair trial. Even if I
he did it,
he did it,
I do.
I still want him to get a fair trial. I don't think that's.
I want it to be proven. I don't care. No.
And for the reason,
Yeah, I do, and I
for it
don't.
makes sense from a policy
Because
standpoint.
that I have
The
very
fair
little
outside
fucking care.
influences, you might go into the
Blood,
research
let there
factors
be
to see
blood.
What I understand was seen, which was there's evidence they did a thorough deliberation. But when there's outside, if there's outside influences that are brought to bear on the jury, that can affect the analysis that gets put up on the wall. And so it makes sense that the way they go through and start analyzing things can be impacted by
What's an outside
influences.
influence?
So how you value things might change based on your
Who has the authority or discrepancy to decide what is outside influence? And if it's outside influence, it goes for the state. Does the state intervene? No, we've seen them not intervene time and time again, especially when the state's fucking trumping up charges, making up charges and shit. But then, to say that the state and the legal argument is, you take said outside influences and apply to a hypothetical person, and you get, you go with what the fucking standard would be, what the norm, what any reasonable person would do. Well, who makes the determination of what any reasonable person would do in them particular circumstances? Because it's obvious that none of us are reasonable all the time. Even all the fucking big blues on the fucking benches and all that shit. And even little cocksuckers like old MERB over there. He's not really a very good attorney because he fucking he argues against something and then turns around and fucking justifies it, what he just argued against. So, but I guess that's what the fucking liars do. They or these liars, the establishment. He's an officer of the fucking court under the contract. And all part of the court. He's got a dress code and the way I understand it, technically, attorneys are the only ones that can be held in contempt. Fucking contempt charges against us are fucking out of bounds because we're not under contract with the court. We hadn't signed a fucking, agreement that we will abide by their bullshit. Anyway. Get the fuck up out of here. MERB, you're a fucking idiot. I'm in the middle of a fucking live stream. You're on there with a fucking cowboy. I'm fucking live. I seen you. Yeah, I was out moving chickens. Yeah, I'm still here. So, yeah. But I give you a shout out. Yeah. So, all right, brother, I'll holler at you in a bit. All right, till then. All right. So, anyway, we'll get back to fucking MERB dumb shit. Like I said, I don't know why he's going over fucking old Ward ass over here and fucking let that motherfucker rot in prison. Everybody fucking needs to forget about this cocksucker. That motherfucker don't deserve fucking I think the shit ought to be redacted. We're gonna fucking go up a little bit and see if we're past any of this. And it looks like I stopped where he might be fucking throwing some more people's shit, so we're gonna go there.
That they were
Maybe
going to
not.
bring in the race of the child or the religion issue, the conversion to religion. And so I think that's what she's addressing here. I don't think that the state or that the defense was claiming that that itself, the lack of notice, required a new trial. So again, this is comments being made were never brought to the court's attention by either the defense attorneys or by the defendant's supporters who were present in the audience. So,
Well, this motherfucker.
one thing that I don't understand is how would a member of the peanut gallery, a member of the public,
Yeah,
sitting in
the
the
idiots.
gallery,
The idiots. Sitting down there in their little,
bring
they call it
to the
peanut
court's
gallery.
attention statements that were made outside? And if they don't,
We're
if
not
no
lying.
one brings to the court's attention, does that mean the statements weren't made? That's going to be a finding of fact that the court is going to get to make. The court will get to make this.
I can
the
see that
Court of
going over
Appeals
real well.
will
Somebody out in
abide
the
by the
peanut
statements
gallery
made.
going, "Hey, Judge, you're talking shit
The
outside.
trial court's findings of fact.
You fucking moron. You're a fucking idiot."
But I'm not. Her argument is essentially it's not true because no one said anything at the time.
Well, that's
Okay,
reasonable, ain't
not
it?
not a great argument, but I don't know really what argument you could make. I mean, you can't really get an affidavit from people saying.
But you can hypothetically
I-
decide what somebody's going to do.
You know,
You can't hypothetically say, well, if they
you have
didn't
to go
say
to-
something then, it
exactly.
didn't
I
happen
guess I've never
then.
seen the affidavits. So maybe if the affidavits were specific enough at at 12:05 p.m. on February 3rd, 2023. I was
then
in
you
the
could-
hallway right in front of the elevators, and person X was standing 10 feet away from me, further away from the elevators, and said why. And then you could have that person, the person who allegedly said the thing.
You can have a sworn affidavit and all that bullshit, specific timing, and you'll accept it. But when you got all the affidavits and shit like that, that shit gets thrown out, and y'all decide what a reasonable person would do in that situation. That sounds like some fucking ring around to go fuck yourself and sticking it to the fucking citizen there, man. What it looked like.
Why an
You
affidavit?
fucking
No, they
idiot
didn't say that
jackboot.
at that time and place or whatever. They could also have someone else say, I was there at that time and place, and I was standing next to person X, and they did not say that. So, without seeing the affidavit,
So, either way it goes, the judge, is going to have the final say on whether it's admissible or not. So, if it supports what they want to do, then it's admissible. And if not, we're going to do a hypothetical, and we're going to make it appear that it's what we wanted it to do. Keep showing us how you're part of the system, you fucking jackboot fucking idiot.
it's hard to say definitively whether or not the state could have brought affidavits to impeach the affidavits of the defense. Judge, you're aware of
It's hard to say, if the state would have brought affidavits to impeach or to get rid of affidavits that didn't support their shit. So, see? Keep telling it. And you're a fucking idiot and think it says that this is good law and fucking practice.
jury had
Fucking thief.
with both the court and the bailiffs, and they made no mention during about any comments regarding the defendant's past criminal history and being a convicted sex offender. These claims are simply unfounded, and furthermore, even if such comments were made, although I don't believe they were, even if such comments were made, there's nothing to show that those comments influenced the jury in any way. This is all pure speculation. Well, again, the standard is
The standard
if the
is
jury heard.
the state speculates in a lot of things and then grabs a little bullshit and fills in the holes and says that's the way it went. And when you destroy their bullshit, then they just get a bigger dump truck of bullshit and keep burning. But I'm by no means fucking in defense of the fucking should not be breathing person that I believe this is all about.
If the jury heard it, then the question is not whether or not this jury was prejudiced by it, but whether the average, hypothetical, reasonable juror would have been prejudiced by it.
Now, show me exactly what that is. Show me exactly what fucking juror you're talking about when you describe that motherfucker. Because you got one specific one in mind that you'll take the word of, and then the fucking rest of them ain't there. Yeah, fucking dummy.
No, there's a dog right there. And there's a chicken right there. 2 chickens right there.
I told y'all I seen his cock. He keeps showing it.
You guys are lying to me about my dog and chickens. Prior to the start of the trial, Judge, you were made aware of the fact that the defendant had a large YouTube following. In this case, it garnered the attention of both his supporters and his adversaries. Given that fact, you expect the jury not to do any research, not to get online to look up anything. And that was so this defendant could have a fair trial. You told the jury that there was crazy stuff on the internet with respect to both sides, that everything that was potentially on the internet was nonsense. And so your comments regarding there being crazy stuff on the internet went to both sides. It was not just targeting the defendant. After closing arguments and the first day of deliberations, Judge Anderson, who commented that 25 years of dysfunction is fit in 2 days of testimony. Of course, it's And she continues, after all the testimony from several witnesses regarding family moving from place to place, having to depend on others for
Teddy
food,
Twister, I remember that shit.
living in filthy, roach-infested conditions, hearing about the Texas Teddy Twister.
No, I'm not with children, but no. As children, we done that shit.
Hearing about one of the daughters having to urinate in a closet in a pile of dirty clothes. All about the sexual abuse. No juror went into that deliberation room thinking that this family was normal.
No family is normal.
Acknowledged that the Warden family had issues. And so any comments regarding the family being dysfunctional had no impact on this jury or any potential juries, Your Honor. The bottom line is that this defendant got a fair trial. He was not convicted of sexual assault of a child because the jury thought that he was a racist, or because he wanted his dog to convert to Mormonism, or because, Judge, you said there was crazy stuff online from both sides, or because you promised he was dysfunctional. This defendant was convicted of sexual assault of a child because the jury believed that he committed the offense. This defendant does not like the verdict and is simply trying to get
That defendant, if he was already convicted, should not be sucking oxygen down to get a second conviction. That's the only one I think that fucking has shit. I'd be able to be brought up in current shit too.
So how are they presented during a trial?
You know, jackboats like you, man.
Motions generally aren't presented during a trial. There might be an evidentiary hearing on a motion. The court could have held an evidentiary hearing, or he could have done like he did here and proceeded off of affidavit. But during the trial, you're not generally doing motions. There are motions in limine that are done before. You can make motions during the trial, but those motions are based on what the court has just heard, generally speaking. You know, like, I don't have
some tiger chip.
off the head. But generally speaking, most motions are handled before trial or after trial. They're not generally speaking handled at trial. And they may proceed based on affidavit, or they may get an evidentiary hearing. So I hope that helps. The court says, in the old Rule 21, you used to have to say granted or denied without comment. Now Rule 21 says the court may make statements and or findings as a part of their judgment. Mr. Garris, is there something you wanted to add? Mr. Garris says, well, I'd like a chance to respond to this argument. I'll be very brief. The court says you can if you want to, but it's all pretty clear to me for what it's worth, but go ahead. Well, what that is saying is the court has already made up its mind.
Yep.
But, yep, go ahead.
He's already made up his mind. Not keeping an open mind. A fair judge, huh?
I have one time, I was just desperate to respond. It was my motion as a moving party. I started off, I made my pitch, The opposing counsel made his opposition, and I was ready to tear everything down, just to shreds. The judge was like, okay, so what I'm going to do is, I'm like, Your Honor, I would like an opportunity to respond. And the judge said, counsel, no, you don't. You don't want to ruin this for yourself. You don't want to talk yourself out of a win. I said, oh, okay.
There you go,
Yeah, but for what it's worth, the court is pretty much saying here that I've already made up my mind. We're done. The Garris does, since this is going to appeal, Garris is correct to argue it anyway. He's got to get his, he's got to make his point because it's going to be his. He has the burden of showing that no reasonable judge could have come to this decision, and that's going to be rough. The sheriff says, well, I think the state's position bolsters our point, certainly with respect to the birth of the biracial child. She says it's relevant to the timeline. My point. Well, I did read this before a couple days ago when I figured out I had it. Maybe it was yesterday. I don't know. Time blurs together. So maybe I just was.
Maybe.
So maybe I'm not as genius as I thought.
Right?
Certainly, the birth of the child can be relevant to the timeline, but injection of the fact that he's excluded.
You're not as genius as you thought.
Because, or she's excluded because she's pregnant with a black child. That's not relevant to any timeline. That just serves to emphasize just pure racial animus. And that's, so we think that fits entirely with what we're raising. I think he has a very good point there. There was some question about whether that was preserved by non-objection. The failure to object is why we say this was deficient performance. But the question about whether
I wasn't listening, Nabby.
The question about preservation of error and whether it's from Rule 33.1 in the Texas Rules of Appellate Procedure that talks about appellate review, not review, as we're doing currently, which is at this trial court level. You can consider that now. That's an excellent point. He doesn't have to preserve an objection at the trial court level on a motion for retrial. You would have to preserve the objection for an appeal on that particular objection. But that's not what they're doing. They're going to end up appealing the motion for a new trial. With respect to the outside influence, and I think it's the perception that Mr. Gray is a friend or associate of Mr. Warden. But I think the perception is that Mr. Gray is a fucking dumbass. I think that was the
probably
perception
think about you, Derb.
As well, but I don't know if there's been anything put that in kind of factual findings. I mean, there's no evidence. He's an independent person that is in the same community that was coming and reporting on a trial. And there's nothing to support the idea that they were friends or that was someone from his camp. John Gray was definitely there supporting Earl. I don't think there's a question as to that. Also,
I don't know who John Gray is, don't give a fuck.
Somebody
I
outside.
wish you'd get off some bullshit, something we're talking about instead of this piece
unless
of
Mr.
shit.
Warden had directed something like that.
Mr.
Also,
Warden.
even if that were the case, it doesn't mean somebody can outside influence unless Mr. Warden had directed something like that.
Read it 3 or 4 more times, see if you can figure out what it
I
said.
think you suggested that even if Gray is Earl's friend, it doesn't mean that he can't influence the jury without Warden directing him. He can still, even if Warden doesn't direct him to influence the jury, Gray can still influence the jury on his own. I think that's what he's trying to say.
Anybody can influence a jury that they come in contact with. What's their fucking opinion?
Finally, with respect to the strategy question of our ineffective assistance of counsel claim, Mr. Landers is board certified in appellate law. He recognizes his own failure, he recognizes it wasn't a strategy. And once the evidence was already in, there would be no basis to object to it. We think at closing argument, because it had already come into evidence, and he had not objected to it earlier. An objection to the closing argument would have failed to preserve anything for appellate review anyways, because he hadn't objected elsewhere, and the evidence had been admitted without objection elsewhere. So we think that goes to the Strickland analysis of deficient performance. Like I said, strategy is given wide latitude, but it's got to be actually a strategy, and it's got to be one that's constitutionally sound. It wasn't a strategy. He recognizes it wasn't. And it wouldn't be a legitimate strategy in a sex assault of a white child case to introduce evidence that, hey, you didn't let your mother stay here because she's pregnant with a black child. It's not relevant to any issue in the case. It's pure animus. It was emphasized at closing, as they said. It may have been a small piece of the overall evidence that was presented, but it's certainly damaging in the same way it was damaging in the Supreme Court's case Dawson to introduce the evidence of being a member of the Aryan Brotherhood when race was not at all an issue that was being tied up in the commission of a crime.
Move along.
So we think we've met our standards. We think Rule 21 guides you, and we've asked for the release. The court has let him finish, and now the court gets to have it.
Get something more talking
Rule
about,
21 has
Dard.
the laundry list of the court must, under the following circumstances, grant a motion for a new trial. It was 7, 8, 89 must conditions. This trial was technical.
Come on, Dard.
It was a highly
Let's
charged
go.
trial. Lots of
Dard.
attention before trial, Mr. Warden was, in fact, a UC personality of his own choosing. There were people on the other side of their own choosing. The trial was well attended by what appeared to be parties from both sides. And we were in a really tight space. We were at the family law
Okay,
center.
get something more fucking
You know,
talking
I've read
about.
these affidavits and highlighted them from work. The odd thing is, in most of them, there's just enough truth to be interesting, but then a lot of, I think, nonsense attached throughout the affidavit. So the court is saying basically that he does not believe the affidavit, which is a valid finding of fact. The court is sitting in a position where the court can judge whether or not these are true or false. And the appellate court is
Sure
going
they are.
to accept
They always are.
the findings of facts and the implied findings of facts that the judge makes. Let's start with just one or two of them. Mr. I Walk Behind the Jury, John Gray. He appeared, actually I instructed several times not to film or record the trial, or not to film or record the trial, to keep the jurors' privacy in the forefront and preserve the integrity of our trial. And several times,
It's not his
several
position or job
he
to.
surreptitiously tried to record, tape record, with the camera on title. I let it slide a few times. I think Mr. Gray, his advice says he was just kind of accidentally kind of walked behind the jurors on the way to their car. He realized he was going the wrong way, and then he turned around and then kind of walked to the next set of jurors, maybe by coincidence. It's not coincidence. There were people
How do you
there.
know?
They were doing their best to intimidate our jury, and I made extraordinary lengths to isolate my jury in a very difficult public space.
His
So-
jury.
I want to point out that the judge, as a finding of fact, has found that there were people there trying to intimidate the jury. That's a finding of fact.
Show me the facts. Where's the motherfuckers arrested and charged
Could
for?
have, and maybe did overhear some screaming in the hallway between a couple of people yelling at each other. That's a finding of fact. Nobody brought to my attention that anything was ever attempted to be handed to them or handed to them ever. The weird thing about this case is at the end of the guilty verdict, I invited your client to engage in substantial discussions regarding sentencing. He was charged with a second-degree felony. He was enhanced with a prior aggravated sexual assault. And if the notice was correct, he had multiple prior felony convictions that could have come in at sentencing. I did tell him, Mr. Warden, your friends may not have done you any favor by their presence in the courtroom. As a finding of fact, the court is telling, as a finding of fact, that outside influences may have affected the verdict.
You're a fucking idiot. Finding fact that outside influences may. How
You
can
might
it
not
be
like
a
this.
fact that may be
You might
has
not like
happened?
this.
You're a fucking idiot.
It's in black and white, right here.
God, you and the fuck, all of them motherfuckers are idiots.
You might not like it. It says it right there.
It may have. A fact may have been. You fucking hear what you're saying? Fucking idiot. It may be a fact. It's a fact that it may be a fact. A fact of
They're
finding.
saying that the court is implying there that,
That the fact might or might not have happened.
oh boy, your friends didn't do you any favors here. You might want to have your counsel work out a sentence with the DA. You might not want to leave it to those folks who might have been
So the judge was giving legal advice from the bench. Is that what we're dealing with here? A judge giving legal advice from a bench? Huh. Illegal, ain't it?
Isn't that weird? I came back and they had agreed to waive jury sentencing at counsel's request, Mr. Warden's request, and the state's consent settled for a 20-year sentence. So it's just a thread of truth throughout all these affidavits. but also lots of substantial nonsense, particularly Mr. Warden's, no, not Mr. Warden, I'm sorry, Mr. Gray's affidavit. I got Mr. Justin Pulliam here in the courtroom, who calls himself, what did he call himself? Investigative reporter, who publishes videos about government accountability on YouTube and Facebook. He said he felt with my accusation that I had chilled his First Amendment rights. Why is the judge talking about this? Why is the judge talking about this? I mean, admittedly, Pulliam's a douche canoe, but why is he talking about this? And he says he was concerned that he'd be seized and held in contempt and or criminally charged for merely attending the trial. What is this? Why? I fucking hate people. I fucking hate people. Oh, Christ. Oh.
Now, was this a finding a fact that might be or might not be true?
Videos right now. Oh, Christ.
Hooked your head, huh, MERB? Christ, why can't I get them brainwashed? How come they won't fucking comply and go along?
I don't even know what to say. Like, Pulliam, you're a fucking idiot. Again, utter nonsense in this affidavit. Perhaps he feels that way, but where that feeling came from, I've got no idea. I don't know whose team he was on. I don't care whose team he was on. My object was to keep this very isolated, away from any outside influence. And Mr. Pulliam finishes up saying, the attitude of the court chilled my speech substantially. Interesting. So this is saying that the court was doing such a good job to isolate the jury and to prevent people from intimidating the jury that he had douchebags like Pulliam saying that they were, oh, my free speech is chilled.
That had no bearing.
But along comes Mr.
Shouldn't even be
Warden's
talked about.
fiancée, Tara Seaver. Says she's outside smoking, and she sees Teresa Richard approach two people she thought was a juror. I never heard a word about this during trial. We were alerted more
I wonder why. Because it fucking probably didn't happen.
By people there. Again, whose team they were on, we have no idea. We were alerted more than once about jurors' concerns about potential intimidation.
If you were alerted, why didn't you do something about it? Fucking get on something else. Shit. Fucking move it.
One time, a person in the audience caught up as I was letting my jurors step out through the public entrance.
As I was letting my jury out, huh?
To go, that was the only way to go at the time. And he got a little too close to my jury and just happened to be leaving at the same moment my jury was leaving. They were not comfortable by his intent, appeared to be intent, to get too close to them. And I told the rest of the people in the audience, you'll keep your seats until my jury is out the door.
Now my jury, huh? So how they view things.
But there were numerous attempts to influence and intimidate the jury.
Finding a fact that may or may not have happened. Explain to me how that works. Explain
That's a finding of fact.
That might have happened. That's what you said a while ago.
That's a finding of fact.
Where are the facts? Where are the facts
Numerous
at?
attempts to influence and
Show me the
intimidate
facts. Just saying it's a finding of facts don't make it a finding of facts. You are a judge, neither one.
They were attentive and intelligent.
It's a finding of, you think you're a fucking sob motherfucker that are the ultimate authorities.
After Mr. Warden agreed to sentencing, I went
Yeah,
to,
see, that's
I
a
went
proper
back
term
to
of
the
fucking
jury
sob
about the
sib right there.
they thought they were going to use
Think that you're the fucking
now,
ultimate say.
remember, it doesn't matter
And
what
that
this group thinks.
we should know.
It,
Call bullshit on your bullshit.
Average, the hypothetical,
Average hypothetical.
reasonable jury.
Well, average hypothetical says you're a fucking idiot.
When I
For
walked
buying
into
into
the
that
room,
shit.
I was stupefied to the point I actually
Stupefied,
what
you
they
are
did.
that.
My
No
first
argument
video
here.
In my 37 years down here.
37
very
years.
well.
Whole 37
They took the
years.
room with giant pieces of white paper, different colors, charts, diagrams, a list of witnesses and dates, show the diligence they did over multiple hours of deliberation.
You know,
I hope that this jury was not influenced. That is my hope. My hope is that they gave him a fair hearing and they weren't influenced by any of the racial stuff. That's my hope. But when I read this, I thought of that Always Sunny in Philadelphia thing where the guy has all the stuff on the wall connected by red threads, and he has that look.
Got a look you have?
MERB,
That
MERB
real
accept
fucking
that,
idiot look?
What do I need to accept? Oh, the fact is that Earl's friends tried to intimidate everyone. Okay, I literally just said that Gray was Earl's friend, and that he was a douche canoe who was trying to do that shit.
I don't know who Gray is, but
No, I can't. No, I can't. I can't accept it. I can't accept it, Teresa. I can't accept it. You're right. My bad. I'm sorry. You know, I try to be nice.
sounds like it.
I don't
You're
think
the
for a
douche
second that
canoe,
race animus
or you're the
certain
douche shot.
Mormonism had anything to do with their judgment. Again, that's not the standard. The standard is the average, reasonable.
What's the average
hypothetical
reasonable?
juror.
Where's your fucking
Our
litmus
complaint was
test out there,
chillingly
motherfucker?
clear about the abuse she suffered. Along comes her sister with the abuse she suffered. The officers put their 2 cents in, but all they could say is, well, this is what they told me, and it was a chilling description of sexual assault. I have no belief for a second that any outside influence had anything to do with the ultimate verdict of guilty against Earl David Ward.
Well, no, he has no belief, but no finding of fact. Now they can find a fact and one thing that maybe or maybe
He
didn't
suggested
happen.
that there might have been outside influence. Now, again, the standard is would have an effect on the hypothetical average reasonable juror.
What the hypothetical average reasonable juror?
Not whether it affects this trial, but whether it have an effect on the average hypothetical reasonable juror. Yes, very much so. Goodbye. As such, I'm going to deny the motion for a new trial. And folks, it's now 1 p.m., 1:05 p.m., and we are in recess. So that was it.
Yeah, you
got-
stay at
you got
recess a
my-
lot, don't you,
with
you
that
fucking
or
moron?
otherwise. And now, as far as the appeal, my gut instinct, my best
Your
guess
assumption?
is that because of the nature of the review, abuse of discretion, Earl's going to lose. That is my guess. Now, if he wins, okay, doesn't make.
My guess.
I mean, it's a prediction, and it's just based on. It's
Based on being an inside member of the club.
Court of Appeals would have to find that no reasonable judge could have come to the decision that this judge made. I don't think the judge is clear on the law, at least my understanding of it. And again, I'm not licensed to practice in Texas, so take what I'm saying with a grain of salt. The judge may know better than me.
Take what
The
I'm
judge may know
saying
better
down
than
your
Mr.
fucking
Hicks.
neck, you cock goblin jackboot.
And I think that a lot of the findings of fact that the judge appears to make undercut the judge's position. But at the end of the day, it's just due to the nature of the appeal, Earl's probably going to lose. Like, if I was giving betting odds
Who
on
cares?
it, I would give 10 to 1 that Earl would lose. So that's it. I think we will go and do some comments, so everybody can get their shake.
Well, you better know them, motherfucker.
Hello, howdy. I don't know what those were. Those were
fat little fucking gorilla or something.
chickens or something. I don't know. A little bit of chili in my life. Okay. Hi, MERB. Help me hook up with Shiz. Hello, digits. Dump truck is knocked up. Is Shiz pregnant? If so, congratulations. Accountability Angel found guilty of 3 or 4 charges. Juries do not like frauditors. I saw Fraud's videos on that, and I haven't followed it, but I'm not sure that they don't like frauditors, but they didn't like her, and they found it beyond a reasonable doubt that she did it. The diddler did. Let's go, Herb. Are you going to review Floyd Wallace's lawsuit? Probably not. Believe it or not, my time is fairly limited now, so.
So your mental
I have
capacity
enough
and your
time
fucking
that I actually want to cover
debate
without
or
covering
argumentative
Floyd Wallace.
skills in the
I
courtroom.
wish him the best of luck in his lawsuit. Yeet, yeet, yeet. 3 good topics. Well, I hope you enjoyed it. Why is your screen blurry? I don't know. It's probably all the season. If it's a secret warrant, how does he know about it? I don't think it was a secret warrant. Again, I think they lie and make up headlines. Shoes would likely give you a single digit. Probably middle finger, yes, probably. Howdy, Merby, you're looking good. Thank you, Chota boy. They have CJ on the case. I guess Cholito was too busy. Yeah, well, honestly, CJ would be an update from Cholito. So, here you go. Hi, statutes and
Codes, dumbass, codes.
codes aren't laws. That's a lie.
No, it ain't.
Thumbs up. There's some case on this in
You're
Texas.
fucking
Some
dumbass,
courts
dude.
require one to surrender the license, not just pressing it to the inside of the window glass. I believe that is the state. You actually have to give the.
No, you don't. Now they're trying to make it that way now
You have to
because
give it
you got the right to be secure in your paper, property, and effect, motherfucker.
Use that because of the way Florida statute is written, they can do it that way in Florida, and I think some people tried to do it in Texas, and they found out the hard way that you can't. He said penal, I sure did. He did say penal. Jinx, laughing. He said penal while not wearing pants. His cock making a racket in the backyard too.
You got one in his neck that he's talking around. MERB's out there fighting chickens. That's illegal, MERB. Fucking criminal.
Indigo's just having nothing to bother. He's chasing them all around. That's interesting. Sidebar, cops can order anyone out of cars. Okay, can the cops order anyone back into the car or order you into a vehicle other than a cop car? Yes, they could order you out of the car. Every state that I have looked into it has basically said yes, they could order you back into the car. And can they order you into a vehicle other than a cop car? My assumption would be yes, because you are
You assume that.
being paid. You're under their you're under their control. My guess would be yes. I've never looked
When
into
you're
it.
under their control,
So
that's
take that
arrested,
one.
right?
Yeah,
Well, fucking quit pussyfooting and skirting shit,
In my
motherfucker.
opinion, Jimmy Springer bids to his audience. Yes, you got it. What? DEET. Killing mosquito. DEET will melt your brain and sunglasses, apparently. I will try not to get it on my
Fucking
sunglasses.
listening to
Mosquitoes hate garlic.
dumbass,
Spray with
fucking
garlic
will
water
melt
and
your
poison.
fucking brain. Fucking
I
idiot
prefer
and a
to eat
pussy.
My garlic rather than wear it. How about that?
Fucking thief.
Few things worse than mosquito bites on a pecker. Probably should wear pants too. Bite your tongue, sir. California Central Valley is beautiful, but scooter heavy. Yes.
Anybody that hires
we
this
have-
jackass
I think we
fucking
have 6
to defend
species
them
of
fucking legally
mosquitoes
is
where I
a
live,
fucking idiot.
and they come in
Might as well
waves,
just
and
give
it's
your
pretty
money.
terrible.
Hell, give it
Avon
to me.
skin so soft, best scooter secret in the world. I've heard of that before, but I don't know of anybody who sells Avon.
Because I do a lot
I
better
know
job than
back
this
when I was
fucking dumb
a
son of a
youngin',
bitch
there
ever
were
could
people
or
selling
would or
Avon
has
all
any
over the place.
information.
It was a marketing
Y'all
pyramid.
ain't
marketing,
money,
pyramid
don't you
scheme,
know?
Whatever. Hi, Merb. I bought some sausage, peas, and chicken Kievs. What's your return policy? I'm assuming it's okay to take straight back to any farmer. The sausages are only 1 year past sell-by date. Thanks. Okay. No, not really a secret anymore, Spartacus. Avon sold that formulation to a pharmaceutical company years ago. It looks like he's wearing pink chili headphones. Okay. Don't raise them. Merb is just sitting around in his flying shirt, no can. Absolutely. Being honest doesn't get them clicks and views. That's also true. Free range pecker, absolutely. Hello, Merb. Hope you're doing well. Hope you're doing well too, Devin. Free range cock, yes. Get your cock under control. I bet Merb has a big cock. I've got 2 of them, maybe 3. Sounds like he desperately needed some brain cells before making dumb decisions. Yes. Yo. They are gang colors, Merb. It was a threatening Christmas card. I don't think so, but that's a funny joke. Oh, Grecki is as much a tool as Chili is a drifter. Both wankers. Sidebar. Cops can order anyone on cars. Okay, can cops order anyone back in the car? I think I answered that. Chicken Hawk Esquire, Chicken Hawk, Frog. You hire a provisional attorney wearing a 10-gallon hat. Better than one wearing an 8-gallon hat. I mean, why not? The 2 Utes. Okay, high attention. Sorry, I had to say, when I read the title, I was hearing it in my head as Mambo number 5. A little bit of Freeman in my life. Yes.
You want it in your
Arguing
asshole,
along the
Merb.
part of their performance craft. And yes. I guess if you're looking at it as a money-making tool, sure. But as a
You are a tool.
as a
Selling fucking
method
clients
of,
down the river under your contract
avoiding
with
going
fucking
to
court.
jail, I would suggest it's not totally effective. Why doesn't MERB have any software with this afternoon? Well, because I didn't sleep last night, and
Too much coke.
I drank a whole bunch of caffeine at lunch, and I went
Done
back
a
to
whole
work
bunch of
and felt like crap,
methamphetamines
and I wasn't able to concentrate, and so I decided to come home, and I can't sleep because of all the caffeine, but I'm super tired. And so I'm like, F it. I'll just
you're strung
I'll
out
just
talking fucking rambly
so
dambly
there you
fucking
go.
shit, giving legal
I
advice.
have plenty of
That
work
sounds
to
like
keep
fucking
doing,
perfect
but,
idea, you goddamn moron. You
Chili
are a
just wants to
fucking
play
idiot,
victim
dude.
against Kate. Well, he's halfway there. Living on a prayer. 3002 doesn't require an arrest all states.
Fucking moron.
I thought I was going deaf. What? MERB, cops doing Jesus. I'll get to it, man. 34th Street for life. Represent. Damn, 31 minutes and still on the same topic. Move on. No.
At least.
Clearly. Frog windows moved that properly. I know. Not gonna lie, it's working for me. That's right. Just dig it. Fuck off, that's my job, you fucker. MERB is hanging out with his cock out. Hey MERB, if they didn't follow us, that's you. Yep. Well, yep.
Yeah.
We really got the best and brightest retards in here today. I said yes, you do.
Yeah.
How's the biker?
Because anybody that fucking does anything on their own fucking does what they do to us, there's something wrong with it. You're a goddamn moron, dude.
Trans people use public facilities as if they're people.
That's the reason you fucking run and hide from me, you little bitch. Where's my assistant MERB? You got to think about it, read it again.
What? Sense or sense?
He ain't got neither one.
Probably not. Frauders and frauder suckers would say, I follow the police around while wearing tactical gear because I can. Sense. Constitutional clown boy. Yes. You guys, please leave the crayons. You don't keep in a neat pile on the table. That's a good point. Lol. Hi.
Pull him out your ass.
Common sense. Wahaha. And that's constitutional cowboy typing with autospell on. Can't fix stupid. That's true. Hey, babes. Hi.
Yep. You're a fucking living example of that one, MERB.
Citizen interactions each year.
Fucking
Yeah,
brainwashed.
there's a shit ton of them. Your odds of getting shot are by the police
Y'all
are
want to
fairly
fucking
low.
run it down to my infamous
Just out of the
fucking typos?
And,
Go ahead.
They
I give a
drop even
fuck.
further if you don't commit crime.
You're done. Yeah, I'm still fucking
And
deciphering.
they drop really far if you don't point a gun at the police.
They drop a lot quicker if you squeeze the trigger
Don't
when you
point a gun
do.
at the police. It's bad
Why
for
not?
y'all. Don't fight with the
That's what
police.
they said about the fucking SS
Don't fight with
marching
the
band over there,
fight the
right?
charges in court.
Yeah, take it to
It's
court.
amazing how stupid
Yeah.
people are. Yes, it is, and they can vote. We're very
For
few.
who's slave master? Fuck voting.
1A.
I don't need another man to fucking decide what I do.
I love tactical stuff. Nice. You can justify their actions and judge citizens for doing.
Yep.
No
Yep.
kidding.
You can't say, yep.
So
Yep.
this point is pretty stupid.
Something
He's
stupid.
not judging the police by their actions. He has created a.
See, now he assumes to
where
know
all
what I
police
know.
do X. And
He's trying to
and
speak for
therefore
me.
he judges all police by it, but he will, number one, not judge the citizens for doing the exact same thing, and not realize that police and non-police are two different things. The police have powers that
Where'd them
citizens
fucking powers come from, dumbass?
imbued by the legislative bodies and the
By who?
governors of their various states with certain powers of
You're
arrest
fucking
and things like
idiot.
that the average citizen doesn't have. They're given
Where did the powers come from?
exceptions to various laws that average citizens don't have in order to allow the police to do their duties. So they're
No.
different. And
No.
so police are intended to do different things than citizens are.
So
And
they're
in fact, do
intended to
different
be
things
a
than
higher
citizens.
class citizen.
And something that would
Like
be
you?
completely normal, ordinary,
No.
unexceptional for a police officer to do in the
No.
course of his job.
What about the course of my fucking rights that are unabridgeable? Huh? What about them fucking rights?
alarming.
Fuck his goddamn job, you
and
idiot.
that is
You're fucking
not
stupid.
appropriate
And
for a citizen to
it's
do,
not
even if it is in
appropriate
the course of that
for y'all to
citizen.
say that we
Their
can't
first
do it when the
job.
Constitution says we
You should
can
say,
for a goddamn job, you fucking moron.
no kidding.
You're fucking
if you don't want
stupid.
problems with cops, just stop breaking the law. I've never had problems with cops.
Yeah.
It's amazing how easy it is not to have interactions with
Yeah.
cops. By doing this one simple trick,
It's
cops hate
easy.
And lawyers
Go
will
look up
tell
my
you,
goddamn record.
this
Go
is my
look
law.
up my
This costs
fucking
me a lot of
record,
money.
you
My taxes
dumbass
are
motherfuckers.
law. Don't break the law.
And just because they put it
And
on
your
paper
odds
and says it's the way it's going to
attorney
be, don't
will
mean
defend
it's
you.
right or lawful.
Go down substantially.
Get on the
Almost to zero.
goddamn boxcar, huh? Get on the
Almost.
train car going to the fucking gas chamber, huh? Fuck you, dumb son of a bitch.
Back to Jesus. I say it's not a good idea for them to do it to their master. Well, that was
Yeah,
that guy. Boy,
because I am the
he
fucking
did
master,
it.
you dumbass.
Yeah, I don't think he was smart enough to know he's American himself. Freeman likes to spin stories to make the cops guilty. Yes, he does. And he will.
Oh,
he
and
will-
cops
he will
don't
tell
ever
you
spend
that
shit to
he's
make
committing a
citizens
crime.
guilty?
When if an auditor did the same thing, he would completely brush it aside, justify it. But the cops get no benefit of doubt or anything. He's automatically guilty of whatever it was. Kidnapping.
Yeah, they are.
Does anyone have the Rosetta Stone for a particular?
They claim to be fucking omnipotent and fucking all-knowing and shit, and you say they're fucking retarded.
Master comes in left. There is a picture of him floating around, a full frontal.
Yes, absolutely. And it's
Everybody-
probably on your fucking screensaver
Everybody-
too. You and GD love that motherfucker.
Probably.
And we do have a
We can
duty.
kill cops. It even says we have the duty to, when they violate their oath, our rights or those of another.
Yep.
That is so stupid.
Yeah, that's so stupid.
I don't even know how to respond to it.
Because you fucking know there's no
mean-
response.
He's just a stupid person saying stupid things.
Yeah.
That is very stupid. That is very stupid. Absolutely. But he's all constitutional and tabloid stuff. Yeah, he's about as smart as a bag of bricks.
Yeah. Well, at least I got one up on you, don't I, Mary? At least I ain't brainwashed.
Dangerous situation. Yeah, I mean, if you don't want to get shot,
I'd much rather
call the
live
police,
with fucking
especially not
dangerous freedom
apparently armed.
than secure
And,
tyranny
Bush
fucking
about,
any
you know,
day of the week.
There's simple tricks to staying out of the radar. You know.
I'm doing other shit, Nabby.
Yes, but it says we can kill cops. He doesn't know. He can't read. CC hasn't done that in years. He knows better. He's typing from the cell in jail. Hey.
Yeah, I'm in jail. My fucking math lab burned up the fucking tent.
Paint chips as a kid.
No.
I'm 100% positive he's never even pet a horse. I'm not
You're
sure
fucking
how
idiot.
have weird
Look at the
outfits
stream
in
from
a
the other
situation.
day.
Who helped the Cowboys spell constitutional? All caps, cut and paste.
Yeah, that's why I done it.
Crimes afoot.
That was put the
Crimes afoot
Constitution
and
before
crimes
anything else,
afoot
you
and
dumbasses.
No one ever has the Rosetta Stone for Cowboys' particular dialect of dumb fuckery. Do these auditors send their dumbest supporters, or are they all this dumb? Yes. Why is this speech garbled? I don't know. They all. They're all this stupid.
Yeah,
why
because
not
we
both?
don't bow down and worship.
It takes a special kind of stupid to be a fraud tart. Well, as a person who's done First Amendment audits, I'm going to say thank you. I'm going to say thank you. Good point. Hating stupid people is my favorite hobby. It's sad that YouTube incentivizes people for being dumb. Yes. Fun fact, juries hate fathers. We've been over that.
Blah.
Again, and wish their stupidity was as painful.
Yeah, how
as
stupid you
as
fucking are when you beg for the goddamn change of oppression. And fucking worship them and lick their fucking boots.
Crime would be easy enough to prove after watching his own footage of him doing it. Ask a cow nobility angel.
Accountability angel. Accountability angel, dummy.
Okay.
You fucking...
Grand juror. I'm only here by special appearance. Grand jurors are not really good. I know.
I'll worship at the fucking altar of the fucking law.
He floats everywhere like the 30 he is. Not the FBI.
And you know what?
According to his right, because I'm here by special appearance, definitely special, revealed elite laws. That's a lawsuit. His mummy says he's special. Freeman thinks it's a good idea, good look. Yes, he does. Where's my trifold? Lawsuit with a Z. You power bottom surfing MERB's chat. That's the place to do it.
Y'all like be
did
over there
you check
fucking
your
licking
spam?
butts, huh?
Freeman's problem is that, like Chili, he thinks he's smarter than he actually is. Yes. He also thinks he knows the law better than he does.
Seems
His
like
Z is
y'all
not
do
silent.
too.
Is it Z or Z?
You gotta know all the
Z.
law to know what's fucking right and wrong.
Use a trident, obviously. I like my spam smothered in Nutella. Cluster B personality disorder is hell of a drug. So here, English is
English.
hard.
English.
Something smiley. I can't imagine a jury would be too fond of this clown's behavior. I'm going to lurk into lurk mode, so have fun, everyone. I'll catch some of you tomorrow. Ooh, that's gross. Alazu. I figured out why Charlie gets confused about how many people are watching, and we'll see him being a bellend. He adds the people who were in chats of other channels he lurked in. My channel will never be
Fuck
shut
how
down.
many's here?
So
Why
no
was
one
that
would be
one
detained
here?
for anything
Everybody
other
else
unless the frauder is a victim, of course.
I'm no
That was
victim.
calling.
Make no mistakes.
HR 7711 forever. That's not the real delete laws. I'm glad someone finally figured it out. There's a fine line between confidence and incompetence. True. But it's actually not that fine.
Yeah.
Don't tell them. That's pretty account's been around for months. Well, never. My channel is as indestructible as my trifold. But the line between ignorance and stupidity is not fine at all. Hemming, I know you're lurking. Probably. So is that like the new trifold or the old indestructible trifocals? No, but sure is fun to point and laugh at.
Diluted, watered down
myself. I
motherfuckers.
miss SC so bad.
Diluted, watered down
Yeah,
motherfuckers.
Great Laws in Chat makes videos about dumb shit, talking balls and crying about mean cops catching and breaking the laws. It's a mirror of Chili's channel. Does the new trifold still come with 3 rubber bands? Oh yeah, he's missed. It comes with 1 rubber band, you greedy bastard. I thought the advert said 1 used rubber.
Blah 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 blah. MERB. I don't give a fuck how many of y'all are over there now. When you start fucking, all you can come back with is fucking ignorance or fucking, you know, trying to take personal shots. I've already won. And it does say that we have a duty to resist and to stand against any unjust or unconstitutional law. That we as fucking individuals have that fucking determination and value. You know, all the laws are supposed to be there to empower us against fucking motherfuckers like you and that fucking establishment that you're over there fucking cock gobbling on. Act like a motherfucker's got to have a fucking 15-year education to understand what's right and wrong. You see, that's where you're fucking ignorant. That's why all of your fucking little bootleggers are fucking ignorant. If you don't know what's right and wrong by what's written in your fucking heart, and you need fucking 10 motherfuckers running around in fucking wigs and fucking black cloaks that claim that they have a fucking higher understanding of shit to guide you to where you know what's right and wrong, or you gotta have it on fucking paper and a set of fucking directions, that's your problem, son. No. That's your motherfucking problem. Anyway. But, flip it, snip it, eat a dick, MERB. Tell us how you're not a fucking member of an inner member of the fucking boys club up there, that you didn't sign a contract to fucking be a fucking, or all this other shit. Tell us how you'll fucking go to the bitter end for your fucking clients, MERB. Tell us. I bet you every fucking one of them, or 9 out of 10 of them, you fucking play out. You sell your fucking people down there. You fucking lie to them and everything else. Because you signed that goddamn contract with the court. Even though you signed one, you know, with your clients there, but, you know, it's obvious that the contract you signed with the court said you can lie to the fucking people because you're an officer of the court. And you can lie to the motherfuckers, and it not be against, you know, because you signed a contract with the court first. You're real smart, you know. But anyway. Talk shit from way off afar, the way y'all little bitch ass always has, son. Just blah, blah, blah. Let your cock holster run. We both know you run from me fucking from day one. But we both know you got that fucking, my pet life account picture fucking on your goddamn screensaver. That motherfucker's still with you. Yep. Just like my fucking record is, huh? I've got such a long, extensive fucking criminal record, don't I? Oh, don't break laws and you won't have problems with the cops. Oh, don't be Jewish and they won't fucking put you on a boxcar. Fuck them and their fucking laws. And you're in your fucking inside little club and out here like you're the fucking ultimate authority. You know, just because it's all right for you to bow down and suck dick and let another motherfucker rule you, don't mean that fucking we're all cut that way. Yeah. Fuck that, man. They gotta have reasonable, articulable suspicion, but they don't mean they have to fucking tell you nothing. Your rights don't really mean nothing here. If they can make something up by the time they get it on the report before a judge, your rights don't mean nothing. You know, it's a little spooky to us that y'all got the balls to follow us around and make sure we're not fucking doing all this shit we've been caught doing as a fucking criminal organization, a gang. But it's suspicious when you do it to us. Yeah, we walk around, you know, we're cops. We're out here fucking breaking into people's houses and dragging them out of their fucking homes and their cars, you know, at gunpoint. And every once in a while, we get a motherfucker that got some balls and knows that fucking, that ain't right. And he'll try to fucking keep us from doing it. So we got to protect ourselves from that one motherfucker that won't get down and suck our dick. But, you know, if anybody fucking out in public is scared of that other motherfucker, something's wrong with them. That's suspicious. You fucking idiot, man. Fucking. I don't know. Motherfuckers like y'all break my fucking heart in the long run, really, what it is. We ain't got to agree on everything, but goddamn, get off your fucking knees and off their fucking dicks, man. Jesus. You know. You fucking weak-kneed motherfuckers. Your granddaddies, fucking great uncles, and all that shit would roll over in their fucking graves if they paid the price that this government tells you they fucking paid in the name of fucking freedom and fucking liberties and everything else, and to say y'all bow down and fucking, you know, support the fucking new age bullshit. The motherfuckers like y'all is exactly what happened in fucking Germany. Subscribe to all their bullshit. Country ain't got a motherfucking chance with weak-kneed fucking snowflake little bitches like y'all. Ain't got a fucking chance. Ain't been worth a fuck for the last 100 years anyway. Since fucking Great Depression they started all this bullshit. But it's the great experiment. Make no fucking mistake about that either. You'll open your fucking eyes and look at what's a fact. But y'all still want to holler fucking conspiracy theory shit. And then when it's fucking proven. One fucking president out of all of them ain't directly related. Oh yeah, to the fucking British monarch. No, shit like that. You know, there's times I don't even know why I give a fuck. You fucking weak-kneed motherfuckers. Now, and you know, y'all scrutinize a fucking cop, the way y'all scrutinize people that fucking, and I'm not saying I agree with all the shit that they fucking do in the goings on. I've done some pretty silly shit in it myself. But I'm still here. And if I ain't breaking the fucking law, so what? You know, but y'all scrutinize a fucking cop the way you do a citizen. If you'd scrutinize a fucking, your elected fucking slave masters, the way you do the citizen that won't fucking follow your slave master, you might be in for a little fucking insight. So, Anyway. We rolling up on fucking 2 hours. So, we're fucking stepping out. MERB, you're a fucking idiot and a fucking jackboot, fucking blue line, fucking cock smoking little bitch. Keep running. You go fuck